that Your Lordship, you grant us these days, we'll be able to conclude our investigation as one on the same date.
Chief Inspector?
That Geoffrey Ndato. Your Honor, we are the state is seeking for orders to have the suspect detained for at least 14 days. And we are seeking these orders on the basis that the IO is investigating a case of attempted murder contrary to section 220B of the Penal Code. The suspect was presented by his advocate, Mr. Beta, yesterday. And from the investigations carried out, the incident happened on the 2nd day of July 2021.
On 2nd of
July at Quiver'S Club in Kasarani within Nairobi. And the suspect went underground and therefore investigations are incomplete. He's not been processed. Just to mention briefly, 3 people were injured. They sustained gunshot wounds. One is critically ill. And I'm informed that one was discharged yesterday. The other one was charged on the same day of the incident. The names of the victim are in the affidavit.
We'd like to oppose that application. We agree that the accused person has been brought, actually the suspect or the respondent has been brought to court within 24 hours. But Your Honor, the investigations did not start yesterday, so that when it's brought today, they ask for time. The investigations started on 2nd. In between that time, the investigators have been going on with this matter. One thing that, Your Honor, we need to inform the court is, while they say that the suspect ran away from the scene, how does that have a bearing on this matter today? Because the same suspect they're talking about, you're being told, was presented by counsel, or he presented himself before them. Can that be a reason then to hold him today? It cannot be. You're being told that he has not been processed. This cannot be true, because I was there yesterday, Your Honor. They took his fingerprints, took his photographs, everything else that they required to do, the descriptive form and everything, in my presence, because I demanded that. So that reason, again, cannot be sufficient for you to hold the suspect for another 14 days. You're being told the victims are in hospital. 2 of them, by my own knowledge, and I know that that is what the investigation can confirm, are already back home. 1 is in hospital. But then again, For that victim to heal, do they need the suspect to be in custody? How does that help? You're being told they need to do an ID, an identification. The victims need to identify the suspect. So today, here we are in front of cameras. Apart from that, officers took his photograph yesterday and they put it on Twitter. It is there on their handle. His photograph with his name. How is that reasonable? That they come again and ask you that they want the person, the victims to identify that person. Yet his face is all over. Today it will be plastered. And it should keep on going on until whatever date. That also, again, Your Honor, cannot be a reason to hold the suspect in court, in police custody. Your Honor, if you look at the affidavit that has been sworn by Chief Inspector Geoffrey Ndato, the notice of motion on paragraph number 7. He has 5 reasons as to why he'd want the suspect in custody. The first one being to record statements. Your Honor, the suspect recorded his statement yesterday in my presence, signed it in my presence, and the officers kept it. Any other statement by any other person does not require that this suspect be present or be in custody at Gigiri police station as they wished him to be there. Again, that one is a reason that cannot be entertained. They're telling you they want him in custody because they want CCTV footages so that they can prepare a forensic cyber report. Again, Your Honor, how does that concern the suspect? He does not work for that company. He does not handle CCTV footage. He does not do the forensic report. So would that be a reasonable reason to give it to make sure that he stays in custody for 14 days? How does he help them to do the CCTV footage? Your Honor, that is not even an imaginable reason. Another reason is because they want to obtain a report from the ballistics examiners. The suspect does not work with the police. He's not a ballistics expert. He has nothing to do with ballistics. The most he could have done was to present his firearm to the officers, which we did yesterday, and they acknowledge. But still, they want him to help them with ballistics. How? One of the other reasons they say is that they want to obtain medical reports of the victims. Again, Your Honor, the suspect here, let's start by saying that he is not what they say is the alleged victim. So if they want other reports from the alleged victim, they deal with the hospitals, they deal with the victims, they deal with the doctors. It has nothing to do with the suspect, so they don't need him there. He is the one they want to conduct an ID parade form, which I've said, an identification parade, which I've said cannot stand at this particular moment. That is water under the bridge. So F, they want to obtain other relevant reports. What is that, Your Honor? What does that even mean? So then it now brings us then to Article 49 of the Constitution, Your Honor. And it is quite clear that the accused person, the suspect here has been brought within 24 hours. It is reasonable time. Let us deal with the other steps now, Your Honor. Let him be granted bond. Let him be granted bail. But for the prosecution and the investigating team, what do they do technically? They now bring you a notice of motion and avoid bringing a charge sheet. Even a holding charge would have been important. They do not do that. So then if we come into the realms of compelling reasons, then you find that the reasons that they have today cannot allow the court to even detain the suspect. The reasons are not compelling. It is true, yes, there is a victim in hospital, and you are being told that we need to wait and see how he will progress and all that. What if it takes a year? What if it takes another 2 years? How then will we justify holding the suspect in court, in police custody? Your Honor, if the prosecution came here in good faith, this affidavit itself, which is in court, the affidavit itself does not even show that actually the accused person brought himself to the suspect took himself to the police officers, showing good faith. He presented his firearm, showing good faith. Gave them an explanation as to why he delayed to go to them, because of his fears. That was also in good faith. Your Honor, even one day to hold the suspect further is on these grounds is not good. Do not allow it. My lady, Your Honor, if they do not.
Your Honor, I do represent the victim by the name Festus Musioka, who is a CID officer attached to Starehe Division. Currently, Mr. Musioka is undergoing a 13-hour operation at Nairobi Hospital, which required an assembly of quite a number of experts, including surgeons, neurosurgeons, and a specialist of shattered bones around the neck and the shoulder area. As of now, the status of his health is not ascertained. Because as of this morning, he had not woken up after the operation, which started last evening. So considering the charge of attempted murder, or if he recovers grievous bodily harm, it will be of importance that the suspect is detained, so that we could have enough time to know which way the prosecution will go. That's all I wish to state for now.
Basically, Your Honor, we are seeking time to allow the victim identify the suspect. The incident happened at night in a club. The moment the suspect will be arraigned, in the moment that we are charging him with the offense, the victims will have knowledge of the suspect, and this will bring about objection of having known the suspect prior. Victim's statement have not been recorded by the virtue of the fact that they were still admitted at the hospital. We have raised other grounds on the affidavit, but basically those are the main grounds that we consider compelling to persuade this court to give us the day sought. Basically, Your Honor, we are seeking time to allow the victim identify the suspect. The incident happened at night in a club. The moment the suspect will be arraigned, in the moment that we are charging him with the offense, the victims will have knowledge of the suspect, and this will bring about objection of having known the suspect prior. Victims' statements have not been recorded by the virtue of the fact that they were still admitted at the hospital. We have raised other grounds on the affidavit, but basically those are the main grounds that we consider compelling to persuade this court to give us the day sought.